Good to go.
Can I go ahead?
Yes, go ahead, please.
Good evening. This is Geeta Mallikarjunan, CEO of HMA, and on behalf of Hyderabad Management Association, I welcome you to the MSME program on the topic Preparing for Future Challenges by Mr. Gadiraju Murali Krishna Raju, Advocate, Law Advisory, Resolution Professional, and Independent Director, registered with IICA. I welcome our MC members, advisors, past presidents, HMA members, and all the others who are present on this platform and also viewing us live on Facebook. I take this opportunity to welcome our convener of MSME, Mr. Peddi Rajendra Krishna Prasad, our secretary, Mr. Chandrasekhar, our speaker for the day, that is today's session, Mr. Gadiraju Murali Krishna Raju, and request our president, Mr. Ramchandra, to take the meeting forward.
Oh, thank you, Geeta ji. Very good evening and warm welcome to all the August participants sitting across different places for today's webinar, which is in our organized under the MSME sector by our convener for this particular subcommittee by Mr. Rajendra Krishna Prasad. The idea is that we also cater to the MSME sector and probably address to the requirements in the way we probably can do in whichever way we can. To address us, we have today Sri G. Murali Krishna Raju, former ITC senior personnel, presently an advocate and a law advisory, insolvency professional, independent director, quite a good a lot of experience in a very high level, and is now presently practicing in these activities. I take this opportunity to welcome all other August members, our Secretary Garu, members present today, and all gentlemen who are across on the web also. It is a proud privilege that today we are trying to see that we give some inputs on the requirements on the legal front to the MSME sector, which is, I think, is a very important aspect, which probably everybody in the MSME sector understand how important it is to be perfect in the legal aspects. That is one part of it. As you know, HMA has been making these efforts continuously to see that we cater to different segments through various programs conducted through lecture programs, to management development programs. Incidentally, we are doing one program tomorrow. Tomorrow we are doing tomorrow, and we have been doing several programs for the students. And one flagship program which we have started 2 years back and it is going very strong is industry readiness program, where we are picking up students by calling them for to join at a very nominal fee of 500 rupees and conducting a program for about 40 hours spread over every weekend, so that they don't get disturbed from the college curriculum, college academy schedule. And they are given inputs basically upon the requirement, which probably they will find it very useful when they graduate from the college levels to the industry or to the business world. And it has we have done 3 such programs, and the 4th one is now about to start. Probably all of you also who are present across may also please put a word across so that more people can join and take the advantage of it, where people like Mr. Raju and persons who are having great expertise, knowledge, etc., in practical field will be interacting and giving their inputs to these students who probably more are nowadays oriented toward the academics. Apart from this, we have also been catering to the women segment and also to the young managers also. This is going on a regular basis, and every year we are trying to improve ourselves thanks to our the legacy that we had. We had good sort of people who are handling the governing the body and building several programs which are keep on adding value to the members at large and general public at large. Today we are now trying to bring this talk on preparing for the future challenges, especially the legal aspect, more probably oriented to the MSME. We'll probably listen to GMK Raju Garu, and who probably will give you his best of his knowledge and the practical insights, which probably we don't find many a time in the textbooks. With these few words, I thank Sir Raju Garu for accepting our invitation and joining our forum. And I'm sure we will be able to see you more number of times in such programs for different segments whom we keep attending to regularly. With these words, I thank our management for asking me to be today along with you. And in fact, I'll be too happy to listen to Raju Garu's talk. Before I hand over the session to Mr. Raju Prasad, who will be giving the profile of Mr. Raju, I'll request August audience to kindly pose their questions in the chat box so that the flow of Raju doesn't get disturbed. Thank you once again, and namaste, sir, and welcome, Raju Garu. Namaste.
Yeah.
Over to Prasad.
Yeah. Thank you, sir. Thank you. Respected our HMA President Ramchandra Garu, Vice President Jayant Naidu Garu, and Secretary K. Chandrasekhar Rao Garu, and our CEO Geeta ji, and today's guest speaker Sri G. Murali Krishnaraj Garu, and my fellow MC members and esteemed HMA members and invitees. A warm welcome and a good evening to one and all. It's my privilege as a HMA MSME committee convener to introduce you all about the topic of the day webinar and a brief bio of our guest speaker to you all. Today's webinar topic is preparing the future challenges in legal aspects for MSMEs. In this webinar, Speaker Garu is going to cover key areas on corporate governance, valuation, restructuring, merger and acquisition. Well, about our guest speaker, G. Murali Krishnaraj Garu. Just a minute. Has over 40 years of experience distributed between managing operations and business in a corporate, advising researchers and startups on business, legal, and intellectual property issues and practices as an advocate. He is currently an advocate with the Telangana Bar. He advises on corporate law, insolvency law, and other business laws. He has appeared before the National Company Law Tribunal, National Company Law Appellate Tribunal, and the High Court. Prior to this, he was the CEO of one of the ITC's strategical business unit and project business head for one of the IT's proposed ventures. He has about 30 years of industrial experience covering various facts, operations, projects, HRIR, marketing, and sales. He has led several initiatives, including ISO 9000 and ISO 14000, International Quality Rating System, IQRS, Export Customer Certification, Juran Quality Programs, ERP implementation, and Employee Long-Term Agreement. As a senior advisor at IIT Madras Center for Industrial Consultancy and Sponsored Research, he set up an intellectual property cell and 1 minute, sir. Yeah. As a part of his legal advisory practice, he has supported over 20 startups in various legal aspects, including investment, advisor, employee, customer agreements, session issues, IPR disputes. As a senior advisor at IIT Madras Center for Industrial Consultancy and Sponsored Research, he set up an intellectual property cell and envisaged the importance of intellectual property with all researchers. The support extended to commercialization intellectual property and guiding researchers who wanted to take their research into startup. He has been resolution professional, advocate, advisor in 10 matters related to corporate insolvency process and updation. Sri GMK Raju Garu completed his BTech Mechanical Engineering from IIT Madras and undergone executive development at Carnegie Mellon University. It's indeed, yeah. I think this is a brief about our guest speaker, GMK Raju Garu. And a small request to all the participants, please keep all your questions in the chat box. So I'll be reading it at the end of the session. And now I request to our guest speaker, Murali Krishnaraj Garu, please take over the session, sir. Thank you.
Good evening to you. Thank you, Ramchandra Garu, Chandrasekhar Garu, MC members, and Prasad Garu for this opportunity to talk on this important topic, MSMEs preparing for the future. Of course, since I'm an advocate, I can only speak on the legal aspects, so that's what I'm going to focus on today. When you listen to legal aspects, it may sound as though it's only the negative part that I'm talking about. It's not that. The objective is that we should caution you on what are the things that need to be taken care of, so those can be addressed. And second, I'm now addressing the MSME forum. So I must just give you what my background and how it's connected to the MSME sector. I've had almost 32 years of manufacturing experience. And during that period, I've interacted with a wide variety of MSMEs, sector players, and also met promoters of these companies. Now, they have been suppliers, they have been partner subcontractors, and in fact, we also had some MSME customers because of the particular area that I was operating in. I've had also the opportunity of seeing small and medium enterprises in other countries like Germany, where I have interacted with them, Italy, US, and also in China. So with that, and of course, I also have a lot of friends who are in the MSME sector who started around the same time and have built companies of a sustainable character. And a lot of the perspectives that they have shared with me have been in the background when I have prepared my talk for today. And while I'll be focused, I cannot go into the business and strategic aspects, but the legal aspects that I'm going to share will in some way be trying to link the two of them. Okay, so with that, I'll start the presentation. So I just need a minute to share the presentation. Okay, so topic is preparing for the future challenges, legal aspects. I'm not going to touch on the current issues that the MSME sector may be facing because those are any case are getting addressed. See, so let me start first the role of the MSME sector. We all know that it's almost more than 30% it contributes to the GDP and 45% to exports and employs almost 11.10 million people. These are as per statistics that are available to me. But of course, there's a skew towards service sector rather than manufacturing sector. And the opportunities that are there today for this sector are arising from almost three different areas. One is, of course, the China plus one opportunity, which is staring at us. The second one is the push for Make in India, especially manufacturing. So there is going to, and I think last week I was reading about the finance minister also mentioning this about manufacturing and the focus and the requirement for MSME to look at this. And the Atmanirbhar Bharat Abhiyan program, where the government has revised the definition of MSME and raised the limits in terms of investments in plant and machinery to 50 crores and other turnovers to 250 crores without adding exports. So all this is an opportunity, and for which okay, this is by way of a summary. Expectations and challenges are there for the MSME sector because the complexion of the industry is going to change. So there's a need for rapid growth of startups and MSMEs through focus on entrepreneurship. MSMEs will also have to move up the technology curve, and they have to learn how to partner with people who have know-how. Also, fundraising will have to go beyond banks to actual foreign investors and other investors. There's also need for adoption of best management practices and professionalism. And of course, competitive pressures because of the global players coming in. So we need to think more globally and act both locally and globally. And there is a lot of hope from the government that the MSME sector will generate the huge amount of employment that is necessary to absorb all the youth that are there in the country. So these are our challenges. So keeping this in mind, and this particular scenario that is adopted is emerging, I wanted to share what MSME could do to win, and I wanted only concentrate on the legal aspects here in this talk. So as we know, any entity has four parts. There's a formation and the funding part, then there's a management part, and also taking care of the shareholder and the stakeholders' needs. Next one is to deal with changes in material events in the business environment. And of course, the last is, if it comes to that, winding up. So winding up doesn't mean winding up the whole company. Winding up can also be for a part of a company. Okay, as you add other companies. So it's need not be taken as a negative thing. So there are 4 areas that I want to concentrate: corporate law, corporate governance, restructuring and M&A, and valuation. Okay, in these areas that I tried to show what parts of the company life cycle they span. Okay, so with that, let's look at the complexion of the MSME sector today. If you see the registration requirements, it says that any one of these 8 types of associations can be registered under the MSME sector. And as per statistics available, 95% of them are proprietary concerns. Now, but if you look at the growth objectives, if you look at the funding requirements and tax efficient requirements and also the control aspects, you need to choose. Okay, there's a menu of various options. But if you really are going to look at those challenges, my proposition is that we should look at becoming private limited companies and thereafter public limited companies as we take the growth paths without setting limits to where we want to achieve. And because we are seeing many of the startups today, we have started as startups are also incidentally a subset of MSMEs, and many of them have gone from somewhere to stratosphere.
Yeah.
Okay, so that's why I am proposing that private limited company and public limited company are the structural options that we should look at for MSMEs going forward. Okay, now why a company form? Okay, there's a lot of matter here, but I just focus on 5 aspects. The first one is that when you form a company, it becomes a separate entity. It becomes a separate legal entity. It's like a person. It's independent of the promoters. That's a very important thing. Second, as a consequence, the liability of the promoters get limited to what he puts into the company. Okay, so the liability of the company and liability of the promoters are different. Of course, unless you find guarantees, which is a different subject, I will not touch on that. The next part is that once you form a company, it becomes an entity which continues perpetually. A promoter can age, but a company need not age. Okay, it can always be revived and it can go on. Next is, as a company, it's much easier to raise loans, much easier to raise funds. So borrowing capacity improves, and as a consequence, the expansion and diversification opportunities are tremendous for a company. Okay, at least the potentials are there. So I'll touch on what a private limited company and public limited company requirements are. Many of you may be already aware, but I'll use this opportunity to just restate them. But before that, in this particular slide, I just want to touch on 3 things which people may not be aware of or may not have leveraged them. One is the 1-person company form, which is available for sole proprietorships, where you can still remain in control as a sole member of the company, but still enjoy the other benefits of a corporate form. The second one is there's a definition of a small company under section 285 of the Companies Act, where subject to certain thresholds being met, the compliance burdens are much less for the small companies which get registered as a small company. So this is another option MSMEs can look at in the initial phases of their journey, and of course later they'll go out of it. The next one is a dormant company. This is again a good innovation that came in the 2013 Act. Because what happens many a time, we find that the incorporation procedures and getting the company up and running takes a lot of time, and lead time is involved. So whereas in a dormant company, you register yourself as a dormant company, so you can even have assets and intellectual property parked there, and you don't need to have significant accounting transactions. Okay, so the company can be in a dormant state, so that at the time when the market opportunity knocks, or if your market has been developed and you're ready, that time you can quickly trigger this and get going. Okay, so these are some features just I thought may not be in the attention of normal MSME players, and it would be worthwhile to bring to their notice. Okay, a private limited company is actually defined under section 268 of the Companies Act. And what is not a private company is a public company. Okay, so this is but the 3 typical characteristics of a private company are that first, the transfer of shares in a private limited company, it can be restricted by the covenants or by the articles of association of the company. Or when investors come in and invest, they can also put in certain conditions into the transfer restrictions. The second one and the last one is that it prohibits the invitation to the public. But that's the flip side. A private limited company can only go to certain designated people for funds who are already members or somebody who comes to them, but they cannot approach the public. And if they do so, the problem is, and then they will become a deemed public company. Like Sahara had a problem with SEBI some years back, and SEBI may then insist that the money that you have collected should be returned back. Okay. In this next chart, I just quickly summarized the differences between a private company and a public company. Okay, I won't go into details here, except that say that the number of members minimum in a public company has to be 7 against 2, and there's no limit on the number of members in a public company. Another important point is that we have discussed share transferability. Fundraising we have discussed. In the case of public company, it is much easier. And disclosure of financial reports and regulatory regime. In the case of public thing, there are a lot more stringency because a lot of public money is involved. And another facet is that in the case of public companies, you need 2 levels of certifications. One is a certificate of incorporation, which is also necessary for public-private company. But in the case of a public company, you also need a certificate of commencement. Okay, so that's the next part. Okay, you can convert from a public company to a private company, or private company to a public company, or from a apprenticeship. Okay, the procedures are quite, there are procedures well laid out. I don't want to touch on that. All that I want to say that it's at various points, if your strategy demands, you may wish to change from one to the other. But you must remember that whenever you change, you have to change your memorandum and articles of association. You have to get fresh certificates of incorporation. However, any debts, liabilities, obligations, or contracts that are there in the existing company, they will automatically go to the new company. Okay, so you cannot change them. And in some cases, if there are disputes, then you need the approval of the NCLT for going ahead. Okay, so in the company law, so what are the laws that you need to be concerned about or be aware of? So of course, there's a companies law, which is the Companies Act 2013, and the rules and regulations which are applicable to that, which every entrepreneur should know, at least in general, what they stand, I think. Of course, if there are cross-border transactions, then you need to go into the FEMA Act provisions. If you get into problems of default, or if your financial structures get stressed out, and and there's an imminent insolvency threats, then you will have to look at the Insolvency and Bankruptcy Code and the regulation under that. If you become a public company and you want to list out, then you need to go under the SEBI Act also, in addition to the Companies Act. And of course, if you're a very large company and then and there are issues with respect to competitive behavior in the market, then Competition Act. But normally this was not applicable so much for MSMEs. But having said that, one time I must also mention, see, we have to look at all laws from 2 ends. One is how to defend yourself and how to use it as a tool. Okay, so a Competition Act also may be relevant for an MSME sector, because if you find that the big player is trying to ease you out of the market, then you may want to go to the Competition Commission to file a complaint and see how to parry that. Okay, so from that point, you should look at laws. Don't look at law only as something, only one facet of it. And of course, there is the MSMED Act, which was also specially been enacted to help the small scale sector in terms of their cash flows and making sure that they get their dues in time. We'll touch on these a little later. Okay. Okay, this is a very crowded chart. In one chart, I've tried to put together what the Companies Act is trying to do. There are 29 chapter 470 sections and 7 schedules. Okay, it's not possible to put everything here. But in a bird's eye view, what I wanted to convey is the left, what you see in the green are the regulations with respect to incorporation of the company, okay, raising of, creating securities and raising funds out of those securities, or raising loans and how to create charges on your assets, because you have to provide security when you're taking loans. Okay, so all that is provided there. The yellow portion that you're saying is basically related to the proper running of the company and making sure that the needs of all the stakeholders are being addressed. So there are things like the board of directors, what their responsibilities are, what the responsibilities of shareholders are, what type of meetings have to take place, how the meetings should they take place. So all that comes in those, plus the rules and regulations below that. The third segment that you see in the red are the compliance enforcing provisions. Okay, compliance. So there is inspection, inquiry, and investigation, or there is a prevention of operational mismanagement of the organization. And on the right, you see when there are changes that take place in the business environment, so you can have compromises and amalgamations that are necessary, or sometimes you may become sick and you want to be revived. Okay, so then what do you do? And then, of course, at some time you may either want to wind up the whole company or wind up certain parts of the company. Then how you should go about it. Okay, so these are all that is being addressed in the Companies Act. And at the bottom, there are certain institutions which are also important. It's like registered valuers. Okay, we'll touch on the valuation aspect later. Then, of course, very important institutions of NCLT and the NCLAT, where you will go for redressal of your problems whenever they come up. And of course, if you go to the wrong side of the law and indulge in frauds, then of course the special courts will come in to deal with serious frauds. So that also you should be aware of. And of course, there are offenses and penalties defined. You should know that. Now, these can be used both ways. Okay, one way is you should try and avoid that you're not on the wrong side of the law. These can also be used if somebody else whom you want to fix and you find that he's on the wrong side of the law, you may use this to make sure that he does not bother you unnecessarily. Okay, so that's it. And then, of course, there are a whole set of forums which you should be aware of. So again, this is in 3 parts. On the left-hand side are the forums which are there basically to administer the law, okay, and also to ensure compliance. So they're like the Director General of Company Affairs, the regional directors, the ROCs, and the official liquidators who come into play because they report to the high courts for what we call mandatory winding ups. And then there is the Serious Fraud Investigation Office, SFIO, which takes care of big frauds that take place. Okay, Satyam at one time, it was around that time when this came up. And then the next part that you're seeing here are the various statutory bodies that you go to for redressal. Okay, the most important is, of course, the NCLT, where company law matters go. In the next chart, I'll tell you some of the things that you can go to them for. Then there's an appellate body, which is called the NCLAT. And then, of course, from there, you go to the Supreme Court if the matter is not resolved. Okay, special courts I had mentioned to you earlier. So those are meant for frauds and other issues like that. Then there is the CCI, that is the Competition Commission of India, which deals with issues relating to competition issues. And then there is an NFRA, which has been recently notified. This is going to be an oversight body to monitor the working of auditors. Ultimately, all external auditors will have to follow the standards of this body. And if there are problems with the auditors, then you go to the NFRA for redressal. And of course, there's one on the side, on the right-hand side, which is more of an advisory body and a guideline setting body that is more for corporate governance. Okay. So, okay, this again, from my experience sitting in the NCLT, I find a lot of cases come up. So I just made a listing of this. So later you can go through the details, but I'll just touch on the main ones. So one is if there are problems of incorporation with the RDs or the ROC, then you take it to the NCLT. Or suppose if you want to rectify the register of members of the company, if some error has come in, then you need to go to the NCLT. Second one is that matters relating to management accounts. For example, if you want to reopen your books and revise them, then you need to go to the NCLT. Similarly, if suppose the board of directors do not call meetings properly, then some members can go to the NCLT and seek that the meeting should be regularly held. Then in the whole area of oppression and mismanagement, this is a very important area, so I'll keep it for another chart. M&A also, we'll cover this later separately, because that's also a very important area. Winding up, earlier were done by the high courts, now it goes through the NCLT. This also I'll be covering separately. Then sometimes, you know, the ROCs may strike your name off for various reasons. Like from some time back, almost 2 lakh companies were struck off because the government MCA order. So a lot of companies had to go back to the NCLT to get restored back. And then any regulatory issues that may come up, if there are investigations and something, non-compliance has come, and if any action is taken against you by the ministry, then you need to go to NCLT for the redressal. Okay, so this will give you a broad idea of that. Okay, I'll touch upon oppression and mismanagement. Okay, where people may give a negative connotation to this, but this is a very important thing. I find a lot of the cases that come to NCLT are basically under this provision. And it basically arises because of disputes that arise in the board, disputes that arise between members. So they all get finally flung into the NCLT, and a lot of valuable time is wasted. So the provision has been made. Of course, a very big example is that of Tata Sons and Cyrus Mystery. Was there in the public domain. But okay, these are high-profile ones. But if you go to the courts, you'll see day in and day out, there's so many such issues that come up. So here in operation, when they're talking about operation, they're talking about basically lack of fair dealing. So the law expects you to deal with all members in a fair manner. The next one is mismanagement. Mismanagement, of course, connotes that you're not managing the affairs in a manner where it is creating, which is prejudicial to the interests of the company. So we make a distinction here. The company is a different legal entity. So if you're prejudicing the interests of the company, or you're prejudicing the interests of the public in general, so then these petitions can be raised. So it can be either as a single petition or as a class action suit. Time that is provided, I may not be able to touch on them, but just to give you an oversight. Now, when you take these actually two things, so one of them is, of course, it can direct how the regulation of how the conduct of affairs of the company should proceed hereafter. Okay, it can also insist that sell off their shares to the majority, but at a fair value. Also, it can ensure that there are restrictions. It can place restrictions on the transfer or allotment of shares. Also, it can block raising of new, bringing out of new share issues. And of course, it has powers to terminate, set aside, or modify various agreements, various contracts that may have been made by the company between, say, the directors and the company and any other companies, or even if sales of certain assets have been undertaken, those can be set aside by the tribunal if he feels that it is against the interests of the company or the public in general. So there is a whole set of other things. It can even remove the managing director and the manager. Okay, it can also insist on undue gains being recovered, and also it can appoint a certain number of new directors. Okay, to take, like for an ILFS case. So after it came to the NCLT, they appointed a fresh set of directors, removed the old directors. So all these actions can take place. So why I'm sharing all this is just to create some awareness. So MMSCs are also aware, broadly of what happens. But of course, when there's a problem, it's better not to go on this basis and start acting. It's better to take some advice with the right persons. Okay, so we have covered the aspects of formation and the forums and what the NCLT does. Of course, the next point is that all MSMEs, at some stage or the other, we all run into problems. Like in life, we also have problems. We'll have sicknesses, we'll have divorces, we'll have deaths, we'll have this. All those things happen. And because of that, disturbances take place. And a company is a far more complex being. And to that extent, there are a lot of problems that come up and they need to be nursed back. Okay, so that's earlier used to be done through the BIFR and the SICA provisions, but now it's all been brought under the Insolvency and Bankruptcy Code. And what can be done is an action under the and what the advantage of this is that once you get admitted, you get a moratorium period. The moratorium period means it prevents people from hassling you. It prevents your creditors from hassling you. So you get some time to think coolly and see how the company can be revived. Okay, so such an application can be filed either by the CD. Here, when I said CD means company itself. Okay, a good example is recently Lido Learning filed a Section 10 application because it was having a cash flow problem. So rather than have all creditors, crowding them out, so they went for this. Okay, for MSMEs, they have a provision which is not this is not available for other companies. Is that the first stage is once it gets admitted, the company gets an opportunity for what is called a pre-packaged insolvency resolution process. Okay, for during this period, while a resolution professional is appointed to monitor the company, but the board of directors and the company still have given some time to come up with a viable resolution plan to revive the company. So if the resolution plan that they've come up gets accepted by the creditors or even approved by the NCLT, then the thing need not proceed any further. The company is allowed to run it on its own. But however, if the resolution plan that is brought in is not accepted by the NCLT, then you go in for a normal corporate insolvency resolution process where now the creditors come into control. Okay, the board is suspended and the resolution professional is put in charge of the company. And the process is that after that, he has to call for expression of interest for resolution applicants. and then he looks at and then invites them, and then he shortlists the resolution applicants who are eligible, and then calls them to give resolution plans. Then the resolution plans are evaluated, and the best one is then put up for a vote. And if the COC approves it, then it goes to the NCLT for approval. And once it is blessed, then the implementation starts. But if suppose you don't come up with a viable resolution plan, then the NCLT may order for liquidation. That is, if there's a failure, then you go through the liquidation route. Good examples of these are, I mean, much talked about. So if you want further material, you can also research. Bhushan Steels, which was acquired, which was first taken over by Tata Steels through a long process of litigation and other things. So that was a good case. Okay, of course, day in and out, if you look at the NCLT site, you'll find a lot of other companies which are coming into this fold. Okay, the third one category of people who can also bring in, and where an MSME, see, people can bring an MSME and take them to NCLT, and NCLT can also bring a big company and take them to NCLT the default in payment of their dues. In fact, there's a big case of a supplier in Chennai who actually took a multinational company to NCLT because they were not paid a 1 crore dues to him. And the exposure and the type of situation that was created, the big company quickly coughed out the 1 crore rather than get dragged on to this. Okay, so these are the provisions. So there's a provision also, like for example, this is a small example which I had to handle of an RK Steel Udyog, which is in fact a proprietary company, which took on a builder called KSR Properties Limited because some payments were not coming during the COVID time, and he pressurized them to get their money back. Okay, this is now so for rehabilitation of the company. This is the options that are available. Okay, now the government has relaxed. Okay, this is a very crowded chart, but basically I just want to put 2 bullet points across. See, promoters of a company cannot normally become resolution applicants because the law does not want that promoters, come back through the back door, because invariably in these processes, a lot of haircuts are taken by the banks. Okay, so they don't want promoters coming back and taking advantage of this. So in order to prevent them from gaming the system, this was made that they have to qualify under sections. The companies in which they are connected, a company, a partner, their partners, or companies, or entities with whom they are partners, they all cannot bid or put in resolution plans for their company. But this has been diluted to, I would say some concession has been given to the MSME sector. 2 conditions there. One is that even if the relative of the thing, or if a company to which they're connected is on the NPA list, that is non-productive asset list of the RBI, even then they can apply as resolution applicants. Now this is only a relaxation only sector. The second one is that they can also submit their resolution plans. Okay, so this is the rehabilitation aspects. Okay, there are further connection methods we can take. Okay, I'll briefly now touch upon winding up. Winding up means liquidation. Liquidation then is followed by dissolution, and finally after you first vehicle company to continue. So after that, you want to wind up. So you go for voluntary winding up. So that is has to be done on the provisions of IBC. Section 59 is the section under which you will do that, because you need a special resolution declaration of solvency, and there's a detailed procedure which in this forum may not be the right forum to talk about. The second part is the mandatory provisions. Mandatory is basically one, of course, as we had discussed in the previous chart, if the corporate insolvency resolution process fails, then the IBC, the NCLT itself may enforce mandatory winding up and liquidation. Of course, the other one is that under the Companies Act also, there is a provision under section 271. The grounds I will share on the next slide, where NCLT, on an application from the Ministry of Corporate Affairs and the department concerned, can also initiate winding up and liquidation proceedings. So what are those grounds? Okay, now, being a legal person, I have to show you the section. I cannot put bullet points here. So it can be by a special resolution because members feel that the companies cannot proceed any further. Business is not viable, so you need to wind up. Second is, it could be also because the company is working on the interest of the sovereignty or the integrity of the company. So if you set up a company which is producing arms, then the company, the NCLT and the thing may say that this is not in the interest of the company, so it must shut down. So it will restrict the right. The second one is, if in the register of the company feel that you are conducting your business in a fraudulent manner, or it is for an unlawful purpose. Okay, sometimes it happens. Say, for example, if you set up a company in a state for producing liquor, and tomorrow suppose prohibition is enforced in that company, then the substratum of the company, which is to produce alcohol, gets pulled off. So in such cases, what happens is it now becomes an unlawful purpose. So to that extent, you need to wind up the company. And another thing is, if you default in filing your financial statements for 5 years consecutively, and then last is if you're just and equitable. So we discussed operation and mismanagement. Suppose there are two members in the company. Okay, one holds 51%, the other one 49%. And there's a tug of war between them, as it happened in the case of, what is that company, Indigo, which was also in the news for some time. Okay, so what do you do? And suppose if they don't come to terms and it is complete deadlock, then the NCLT may in such cases take the last recourse and say that, look, okay, you wind up the company. But that's the last stage if nothing else works. Okay, they will exercise a lot of the powers that they have under Section 242 to ensure that conformance takes place. But if it doesn't work, then this would come into act. Okay, then I just want to touch 2 slides, because a friend of mine who's from the MSME sector, he said, if you're presenting, then you must certainly touch on these 2 aspects. Because he says that his view is that the MSME sector is not leveraging these provisions adequately enough. Okay, as you know, in the MSME sector, Section 15 and Section 16 provide that within 45 days, a big company must pay. Okay, if it doesn't pay, then 3 times the RBI rate can be sought by the MSME sector. And it also specifies certain companies which have to report every half yearly in terms of what their dues to the MSME sector are. And if they don't do, there are certain consequences under Section 405, which I'll just show you on the next slide. But the process is important. Okay, the process is, of course, if you want to invoke this process, you have to first, of course, be registered. Not necessarily at the time when the transactions take place, because courts have said that it's not mandatory. But at the time when you initiate the process, you should have been registered. The first important that you have to put out a legal notice. And then you have to refer the matter to the SME Facilitation Council. Okay, a precondition, of course, that you must have your documentation well taken care of, because otherwise, you know, you'll have a weak case. And your contracts also should be well taken care of. Most importantly, dispute resolution provision. Though, of course, the MSME Act has been a little liberal in this aspect. What it has done is that it says that even if the contract does not provide for it, it has provided deemed provision. So it's assumed that the arbitration clause is there, even if it has not been there. So first thing that they do is they try and they execute conciliation proceedings between the 2 of y'all to see if you can resolve the matter. If it's not, then it goes to arbitration and thing, and then of course an award is given. And the award then goes to a normal court. The 405 provisions are draconian provisions. So if an MSE wants to exercise it, it can exercise it. So I just, for information. Okay. So we've covered the Companies Act because that's the most important. So that's the foundation. On that, of course, there are other things that are sitting in, like the corporate governance framework. Now, a lot of the corporate governance framework has also come in the last 10-15 years only, and it has evolved and it's evolving. It's not only in India, but even around the world. Okay, this actually sits on 4 main pillars. It is trying to seek to establish accountability. So as we discussed, see, in a company form, what happens? The company is a separate entity. Okay, and it is run by member and managers who are different. So it has to make sure that the managers don't work into their own interests without keeping the company's interests in mind. In order to ensure this, the framework of corporate governance has been brought in. So pillars are accountability, how to assign accountability to the management and the directors. Second is how to ensure transparency, so that behind the veil of the company, things are not done which people do not come to know. Investors don't get to know. Okay, so transparency aspect. Third is to make sure that responsibility is properly assigned in the organization, so that it does not become a case where nobody knows who's actually accountable and responsible for things. And of course, fairness. So corporate governance is essentially a set of rules and regulations, procedures and policies through which a company is protected and controlled by its management. Okay. Okay. A lot of people ask why corporate governance. Oh, so it's a thing. It's one more burden for us. Compliance. A lot more other people. But we must remember that if something goes wrong, the costs are very huge. Okay. So it's a way of like a health checkup. So people may say, why should I spend 10,000 rupees, go to Apollo and get a full medical checkup done once in 6 months? If I can avoid spending the money, I can take care of things. But it's something similar to that. I mean, not exactly similar, but it's like a framework that is necessary to make sure that a company doesn't, because of mismanagement or because of oversight or because of risks in the outside environment, doesn't become sick. So a lot of things gets lost. So basically, if I may quickly summarize, run through this. So regulatory, once you have a good corporate governance framework, regulatory compliances reduce willy-nilly. You'll find a lot of people accept thing and don't go poking into your system unnecessarily. Second is that even providers of risk capital like banks, private equity and venture funds are also more comfortable when they're dealing with a company with good corporate governance and probably will come up more easily to lend to you. Next one, of course, it's been established from research into companies. The long-term financial results are also better when good corporate governance practices are adopted. Of course, even shareholders, stakeholders feel more comfortable. They know what's happening in the company. Of course, growth and efficiency also are better. And most importantly, you mitigate risks because corporate governance also expects you to look forward 5 years or 10 years ahead and see what risks are there. So you don't have less risks of business failures. Okay, even insurance is more comfortable. And of course, corporate governance helps also build trust and company image, which, as we all know, are very important when you're dealing with somebody else, because he is not from your company, he's somewhere else. So he has to, so if you're getting mergers and acquisition, so it plays an important role. Okay, the basic framework, okay, again, it's a crowded chat, so I don't want to spend too much time. Just broadly, there's an external governance framework, which is all the legal and regulatory environment that I'll touch on in the next few slides. Next is there are various institutions there, like from stock exchanges and various other institutions, which are also have set rules. So if you want to deal with them, then you have to follow those rules. So those are aspects. The second, professional bodies today, if you find chartered accountants have their own standards, audits have their own standards, company secretaries have standards. So as time is going by and you have problems of corporate governance, these standards are becoming more and more tighter and to be adhered to. Then internal governance also, you see in a company, there's a division between shareholders, board of directors, and the management. There are 3 different bodies. Okay, so there's reporting and accountability which goes upwards, and appointment and reviews come downwards. So this structure is creating checks and balances in the system to ensure corporate governance. So if you go into the framework, you'll find a lot of regulations. Then, of course, there are external auditors who are also supposed to play a role. Then, today's world, there are roles. It also will become suppliers to large companies. Okay, those large companies may have high standards corporate governance, which they may translate, and there are look at. Okay, the legal framework. Okay, it's important ones are in the corporate companies. There are various acts that we'll cover them a little later. And of course, if you're a public limited company and you go for listing, same things are also applicable, but more.
Sir, sorry, sir. We are having some weak signals from you.
The frequency of doing international practices are also. Sorry, sir.
Sir, there is some problem with your network, sir. I think you can switch off the video. Maybe they will have a clarity in talk.
Okay, I can do that. One second.
Maybe the bandwidth issue.
It may be fluctuating a little bit. I'll just one second. No, are you able to see now? Because I think otherwise I'll have to go out of the presentation and come back.
Yeah, I think it's okay, sir.
Okay. No, I think a little fluctuation is there. So there is the SEBI provisions which have to be also okay. So what I've done in the next slide is actually combined all of them together and giving you a flavor in a chart of various things that are required normally. Okay, now with respect to large companies, it is mandatory to follow all this. But for MSME, I just highlighted some of them which are in green, which probably are the requirements for an MSME to look at. Okay, I don't need to run through all of them in detail, but here again, I want to share what a perspective that one of my friends from the MSME sector had shared. He said MSME people must always monitor various portals that are there today, like the MCA site, SEBI site, RBI, and Dharani. Because if there's any mention of you in those sites, you must quickly address those problems before they become unnecessary devils. Okay. So in fact, he shared a problem that he had with the Dharani site, where he said there was a land and property which was a part of the company for the last 15 years. Okay, and he never thought there would be a problem. And recently, when he was one day accidentally looking at the Dharani site, he found that that land registration had been knocked off because the government has suddenly decided that those lands in that area would all belong to them and not to the people who are the true owners. Okay, so these are all corporate governance issues, because governance ensures that by rotation you look at, and for a defined frequency you look at various aspects of the organization and don't get blindsided. Okay, so that's why you try and bring independent people or non-executive person, because they bring other perspectives and they ensure that all aspects are being looked at and not being missed out. Because even a proprietor, after the company starts becoming bigger, it's very difficult for him to be aware of what's happening everywhere in the organization. So some of the adopting these governance practices will help him make sure that his risks of failure get mitigated. Okay, so with that, okay, that's with respect to corporate governance. So just give you an overall idea. Okay, now the next subject, which is very important, and in today's world, because various transactions come and go. So valuation is an important one, and requirements of valuation are embedded in a lot of acts, like Companies Act and Income Tax Act. Income Tax, I know a lot of people must be aware, because if you sell an old property, then you need to get a valuation done, because otherwise, and that can be subjected to a lot of scrutiny by the income tax guys later, depending upon how much you have claimed. Okay, these are all there, but today the valuation requirements are in different acts. So the current government is trying to bring a single valuers bill, so that all these provisions are brought into under one act, and a single set of body of valuers can do any valuation depending on their qualifications. But what purpose, but I just want to put under Companies Act, it is prescribed that if you're issuing shares as sweat equity or on a preferential basis, because you're having investors coming in who want to take a stake in the company, or if you're giving ESOPs to your employees, then all these need to be valued by qualified and registered valuers. Secondly, if you have non-cash transactions, suppose an office building is being donated, given by the director for the use of the company, then valuations are required. On the other side,
Sir, switch off your, sir, Rajgaru, kindly switch off your video, sir. Sir, kindly switch off your video, maybe the bandwidth will improve. You're not able to hear, there's a break.
I'll just put it off.
That's it.
Is that okay now?
Yeah.
Better, Andy? Okay.
Yes, sir, yes.
Okay, so I don't want to get into very detail of each and every item, but one thing I want to mention, which I think a lot of SMEs don't focus on, which is the aspect of intangibles. Okay, intangibles means the trademarks, confidential information, some potential patents. So these are all things. So they need to be protected, and also they need to be valued, because sometimes, okay, in India today, banks are not yet lending on the basis of intangibles, but tomorrow they could, and could be an important area to look at. Okay, okay, this again is a crowded chart. I just want to explain how a registered or a qualified valuer has to do his job. On the left side are the inputs that he has to take. So he has to know what is the objective of valuation. So as we know, if you're valuing a property, if it's for tax purposes, you want one type of valuation. But if it is for the selling to somebody else, you want a different type of valuation. Okay, so these are important. And of course, so the assumptions of the industry, limiting conditions, and also the quality of the data on the date when the valuation is done, all these have a role to play. And I've also tried to tabulate some of the various inputs that the valuer would require. And then, of course, there are standards of how valuation should be done. There are n number of different models which can be applied to valuation. So the valuer decides, depending on circumstance, which one is the best. Of course, it also depends on the stage of the business. What is the end purpose for which you want the valuation done? And then he finally gives a valuation report. Okay, I had a misconception earlier. When you go to a valuer, he'll give you one figure and say, this is evaluation, and give you one-page report. It's not enough. Today, they are required to give a full detailed report where they capture all the things that are required. And specifically with respect to MSME, what has been at least expressed by some valuers, that there's always a problem of transparency of the historical financial data, and that they get stuck. Second is a lot of the business methods and processes that are not documented, so they find it difficult to give assessments. So this needs to be borne in mind by the MSME sector. Okay, just a quick snapshot of the different techniques. There are enormous number of techniques that are there, and we cannot touch on all of them. So there are broadly three ways that evaluation is done. One is what we call an income or economic value option. In fact, in the later chart, again, some example. Here, if you know what is the future revenues likely to be, how much money, let's take an example of a toll road project, toll gate project. Okay, what are you looking at? You're looking at what the toll values are going to be in the future. Okay, you will also look at what is the type of traffic that is going to be on the road. From there, you derive what is the toll revenue that you're likely to get in the next 5 years, and then beyond 5 years, what is it likely to be? And then you need to see what is the return that you have to give to your investors. And then also you need to also look at what are the types of risks that can happen. Like, for example, you have toll gate project where government comes up with the legislation and says, look, you cannot increase toll revenues beyond a certain value. So all these have to be factored in, and then they arrive at a value of the company today. So because 5 rupees, which you get 5 years later, may be valued at only one, maybe worth only 1 rupee today. So those factoring has to be done. The second one is, of course, the market concept. In the market way of valuing, what they look at is what is the value of comparable transactions that take place in the market. To give an example, suppose if I'm buying a property in some place, so I will look at what value other properties in that area have been sold or bought recently, and then from there I try to derive what should be my value here. Okay, there of course there are a lot of techniques. You need to factor for risks. You need to factor for the type of management. You need to type the country they are operating. Okay, they all are used to basically adjust the valuation. Okay, but basically, of course, last one is what we call an asset or cost way of coming to the value. These are normally used when your company is due for liquidation, so you don't have any future revenues that are there. Or if a company has just started its work of setting up, you're building the plant and machinery, and you have not yet come down to what are likely to be your future revenues. Then you look at basically this. So here you look at what are the tangible assets, what are the employee costs that have been incurred, and what type of working capital you need to block, and use that, and then we add them all up to come out with the value. Okay, so those are some of the examples which I put on the next chart. I think I've explained this chart already in the previous section, where what is relevant. So I'll skip this and move on. Okay, valuers with respect to the Companies Act have been defined. I mean, the requirements are there in section 247 of the Companies Act, and the valuers have to be registered under the IBBI, and they are categorized into 3 portions. The registered values for securities and financial assets, registered values for land and building, registered values for plant and machinery. There are 3 different people. They have to qualify for them, write a test, and then get registered. The list of these people are available on the IBBI site. You can go and look at them if you don't know somebody who's already there. Okay, having said that, I just want to conclude by saying one remark with respect to valuation. You must always remember valuation is a subjective thing. 2 different people's valuations may never be the same. So in fact, even in the Insolvency and Bankruptcy Code, there's a regulation which states that in the minimum you must get 2 people's valuations. Okay, 2 people, and of course you must make sure they're independently selected. Okay, there cannot be a bias in their selection. Second is that if the 2 valuers come up with a widely deviating, widely varying valuation, say suppose more than 25%, then the regulation mandates that you have to bring in a third valuer to value. And then once you get the three figures, you have to see which are the two closest to each other and then take the average as the valuation. So this is basically to tell you that valuation is a subjective side, but okay, and it's always good to know valuers. So I know I have short the time, so there's only one last aspect which I wanted to cover, this aspect of restructuring an MA. Okay, I'm not going to get into a very detailed presentation on this, but just for MSMEs to know, because we find that a lot of MSMEs think, they do not think and prepare for restructuring and M&As. They're so engrossed in the day-to-day operations of their company, they do not know that at some point these aspects also have to be thought through, and always have a backup plan always there. So there could be issues of, okay, what happens, and I just borrowed a chart from the net. And when a company comes to maturity, or even earlier sometime, what can happen is sometimes a decline may start because of factors which may be beyond their control, or sometimes there may be factors which may be created by their mismanagement or something like that. So it may be a decline that may take place, or sometimes the promoters or the members may want to exit. Okay. So because of which certain decisions have to be taken, or sometimes in their companies they feel at some point the products that they have flogged all this while are no longer just going to sell for too long. So they need to reinvent their, redesign their products, change their portfolio and things. So that's where corporate restructuring and M&A play a role. Corporate restructuring is more to do with how do you restructure your, say, your financial structures or the operations or the management. Okay, that is a little more in the here and now. Mergers and acquisitions relate to bringing new partners, like getting married, you bring a new partner in, okay, or you want to get divorced, and so you also then at some stage. So that is mergers and acquisitions. So I'll just quickly run you through these last few slides. So there are two sides of this field. There's on the offensive side with the growth side, and there's the defensive or the shrinking or exit side. So on the growth side, it's a tabulation. You start first with cooperating with somebody, okay, which does not require too much of legal inputs. It's more to do with agreements. Then you get into strategic alliances. Of course, it's a more structured and a more formal thing. So again, more stringent agreements. And joint ventures are when two companies together come in and then set up a third company in which both of them have stakes. So you have joint ventures. Then of course, at some stage, one of them feels that the other guy can be dispensed with. So then they start wanting a higher stake in the joint venture. Usually what happens when foreign companies come into India, they get into with a partnership with an Indian company, but at some point they start getting ambitious, and then they want the Indian company to start exiting out. Okay, so then so that stage they come into acquisitions or merger. Okay, difference between mergers and acquisition: mergers, two entities get together to become a third independent entity, and the other existing entity which merge lose their importance. On the defensive side, a lot of things that can be done. Here I had a small clip that I picked up from the net. Earlier, 2019, they acquired a portfolio of 7 oncological injectable products from Spectrum Pharmaceutical. But in just 3 years, they're selling their stake in that. So it's basically to bring out the dynamic nature. And I think SMEs must also start getting to look at this facet interestingly, because then you can avoid a lot of insolvency matters that come up into the NCLTs. Okay, why we should consider M&A? Okay, I know a lot of you must have studied this in colleges itself, but okay, just to reiterate, the first and most important thing, many times companies want to eliminate competition. Okay, you don't want too many players in the market. Then the problem is you cannot command good margins because each person then kills the other. Like Ola and Uber, I believe they were in discussions to come together. So of course, a few days earlier, I looked at the news and it said, oh, Uber has denied any such moves. But basically, you're trying to reduce the number, like from Idea and Vodafone merged together, you reduce the number of players, so you don't have destructive competition in the market from a company's perspective. The second one is for growth, security and of supply and synergy benefits. Also, you sometimes have to consider these. Like for example, if you want to, suppose there's a player in the west and there's another company which is in the east, but both of them now want to go to the north. So they may decide that they may need to come together through a horizontal merger and acquisition and bring their strengths together to now beat the guy in the north. Okay, next one is you could have a company which needs certain resources. Say, suppose you can have a power plant which needs coal, okay, and it feels that the coal is not is from a separate company. So you may sometimes want to ensure that your coal supplies do not get knocked up. I'm sure Adani, that's why went and bought off companies in Australia, because he wanted to make sure that the coal supplies to some of his requirements were ensured. Of course, he's gone to merger, he's even bought ports to make sure that that is also secured. Okay, so you're basically trying to secure their talent and resources. And of course, conglomerate ones, which are not so relevant for MSMEs, but for large companies, and they try and get in for portfolio diversifications to make sure that the company's fortunes in the future are protected. Okay, sometimes it's also for intellectual property and know-how. And another important area, sometimes companies come together basically to reduce their costs. So they may want to eliminate, reduce manpower, okay, reduce marketing costs, or sometimes to get tax benefits. So all these, and also banks, investors and promoters may come forward sometimes to get out, okay, for various reasons, or for resolution of stress assets. So here was I picked up, okay, though I'm from the company, I don't know the actual reasons, like ITC acquired a small company called Sunrise. So I suspect it could have been because they have already set up a factory which they could quickly acquire, and a running factory. So it reduces the time for the company to enter that segment. Or let's take the example of Tata Steel, which I think we mentioned earlier. Bhushan Steel was a stressed asset. So Bhushan Steel came onto the block as for CIRP. Tata Steel put in a resolution plan and got them in. So this could have been also to reduce competition, also to grow in size and get market share. And at some point they merged Bhushan Steel, which was acquired, which was first redesignated as Tata Steel BSL. And then of course, when acquired, that entity was extinguished. Okay, when you come into M&A, this is again a list I've prepared. I don't think in this forum, but you could definitely go through the slides because they'll be available to you. And if there are questions, you can come back to me later in specifics. You can. These are all the provisions. Of course, there are a lot of other small things also which come in. And last one, agreements. You must remember that a lot of after the merger and acquisition, you may have purchase agreements which need to be handled. Okay, there could be supply related agreements which are so all those have to be taken care of. And that's why it's important that it should go through the NCLT process so that the orders of the NCLT are at least followed by various people. So instead of you trying to struggle to convert and get people to accept them. So in the, of course, I will not go into the provisions which are there under each of these acts. There are a lot of them. So it's itself is a vast subject. But under Companies Act, there's 230 to 240 are the provisions there. And the important provision 230, which allows you to compromise or make arrangements with creditors and members. Suppose you want to renegotiate with your banks the loans that are there, you want to re-engineer them. Then of course you need to go under 230. Second one is of course you want to merge or amalgamate. Say suppose I have examples of people who have set up multiple companies at one stage because they did not, because there were restrictions of the limits in terms of the MSME thing. You know, you had 10 crores or 20 crores or something like that at that point. So you set up several companies. But today, since the things have gone up to a much higher level, you may want to now consolidate all those companies because the limits have now raised to 250 crores. Then you go through this option. Of course, while the Act provides for certain things, but the important rules, regulations, the processes are all in the rules. So those must also be gone through. Okay, I think I'm sorry I'm coming to the taking a lot of time, but I want to conclude with this slide. Here I've tried to summarize the processes, okay, steps. Okay, it's a little academic, but it's important to keep this in mind. The first, as we said, MSMEs do not spend much time on strategy and planning. I think they get a lot lost into the day-to-day operation and all the headaches that they have to manage with the external environment and dealing with compliances and other things. So there's a need to look at, but we can learn some lessons from large companies and try and factor them into our day-to-day work. The first one is that I think MSMEs also should look at, what are their deals that they feel that they should strike in the future. So big companies look at deal databases. They keep an inventory of potential candidates for mergers and acquisitions. And there's a whole departments and divisions which just focus on this, and they study them, and they create an acquisition program. and they evaluate candidates both in terms of accounting and tax effects. And then also they look at what are the payment options that have to be considered. So this work goes on in the background, and the appropriate price they're tossed for the current management to look at. Okay, they're very similar to when you buy say if you want to buy an old villa. Okay, obviously we'll need to look at whether their encumbrances are not there. Okay, you need to check out what will be the tax implications. Okay, so those are things. So you do due diligence. So before you negotiate or alongside that you're negotiating the deal, you do due diligence in terms of legal nature. You don't want any disputes popping up later. Okay, I suppose you're taking the housing example. You want to make sure that the title deeds are all correct. So same thing with the company. Operational aspects, you want to go and see the villa and make sure that the floors are okay. Okay, the wall paintings are okay. So similarly, like that, you may want to go into a company and see that the machinery is in good condition. Okay, the technology is not obsolete. So things like that you will do in the due diligence part. Then you'll go and look at the financials. Like pyramid in a house, if you go to villa, you want to make sure that some side deals, the guy is not only put a charge on the property and taken a loan, the person who's selling it. Similarly, you check out. And of course, another thing with companies, and even for MSME is very important. When you're going into deals, if you're looking at a merger and acquisition, you have a problem because you have to open out your company to outsiders. Okay, so you may have a lot of proprietary information which you may wish to protect. So you need to do this carefully and have the necessary confidentiality agreement when you go through this. So once all that is done, you then have a due diligence report, and then of course you'll have to do the bargaining. This is the most toughest part. So when the bargaining takes place, you have to use all this information that you have to bargain to get a good deal. And okay, this is all management part. Okay, the legal part is in the third portion, which I put down here, is because ultimately whatever you want to do must be blessed by the National Company Law Tribunal. And you okay, so the preliminary steps are that you have to have a scheme. What is it that you want to do must be in writing. Okay, who are the parties? What are the accounting principles you will follow? Okay, what are the type of, how will you deal with all the stakeholders? Okay, things like that. So that's the scheme. Then you have to put all your documents together. You'll find that it's a really structured process that has to be carefully managed. And then when you go to the NCLT, there are two steps through which the NCLT, first what we call a first motion. You first apply to the NCLT to direct all the members and the various classes of creditors to come for meetings so that these schemes can be presented to the various stakeholders, and you get the due approvals, because the law mandates that a certain percentage of people must approve the schemes. Okay, otherwise you cannot go forward. So that's a laborious process, so which has to be handled. So that's the first motion. So once you go past that and you get the necessary approvals for members and creditors, then you go to the next, what we call a second motion. That is when finally, with all these approvals and all the documents, everything, you then again go to NCLT to now give an order for the scheme and approve the scheme, so that that order can then be taken to the registered companies and the RDs, and then further work can be done in terms of changes to the certificates of incorporation. So all the documents in the ROCs have to be changed. Okay, and then you have to go and change the name of the company in various permits that you have. So all that has to be taken care of, which is in the integration and the post-transaction part. Okay, there are some management aspects like complementary or top teams deal with that culture parts, but I will not touch on those. But when you bring two entities together, you'll have retirement benefits, you'll have ES and EPF, employee provident fund issues, and all those things have to be tackled in the accounting books. And of course, if you have purchase power agreements or some other environmental licenses, you have to make sure that the relevant bodies recognize that they now belong to somebody else and update the records. So that's about all. So I want to now stop here for any Q&A. Okay, but only thing I just want to mention two things. See, whatever I have said, our subject matter is a very vast subject. So I know I had to run through it. And also I would recommend, okay, it's a general thing. And as all lawyers, I would like to make a disclaimer at the end. While you may use this information for understanding it, but we do not take one part of it and act on it without getting, especially because law can be interpreted in several ways. And also law can vary depending on the circumstances. Okay, so I just want to put that final rider. And with that, I throw open and I'm available for any question and answers.
Sir, Ramchandra Garu, I think it's
Yes,
your
I-
subject, sir. I think you have as experience in the same field. You can take up some questions, sir, and then you can have a interaction with him. The really park presentation, Raj Garu, I think is you've given a whole law in one capsule about 1 hour. Huh? I think, yeah. I request Ramchandra Garu, I think is your sir. Can I take out some questions, sir? Or you will
Yes.
proceed? Huh?
No, yeah, I think you can take over, but I think as you rightly mentioned, sir, I think you have put up the entire law that has been framed over so many years into these
Yeah.
slides. I think it is a very absolutely a reference type of presentation that you made,
Yeah.
sir. A wonderful, your knowledge and the eloquence that which you have told talk speaks well of your ability on this subject. I'll request, I think maybe my friend Chandrasekhar Garu will give the word of thanks. But before that, I thought that yes, we should be complimented for the wonderful session. And in fact, this is a subject which probably many people will find it little dry and all that. But you made the time go like that, and probably you'll take few hours more if you're allowed to. Thank you very much, sir, for your excellent thing. But maybe Raju Prasad Garu can go through the question answer. I think there are some questions. Of course, I also put some questions, but I can ask them if you want. But I think other people also made some queries.
Yeah. Okay, sir. I'll ask that.
Hari Prasad Garu has asked some question.
Yeah. Yes, sir. Yeah. Sir, Harprasad is saying, sir, it is a specific question. Advocacy and insolvency are two different professions. How could you manage it? Can they considered as a conflict or complementary?
Just repeat that question, sir.
Yeah. Advocacy and insolvency are two different professions. How could you manage it? Can they be considered as a conflicting or complementary?
No, actually, this question had come up because, as we know, in India, each profession is a boundary. There is a boundary for that. But since IBC came later, the law has provided for chartered accountants, company secretaries, and even advocates to become insolvency resolution professionals. That's one part. So you can do both the professions. But the more important part, you must remember that ultimately, even when you run a company, you're ultimately
excuse me, sir. Sir, you can close this PowerPoint PPT and you can open up yourself, sir. That will be fine. It's visible. You can close the PPT, I think now. Hello? Yeah.
Yeah, I'm just trying to see how to do that.
Maybe you have to put on your video also, sir. Video also maybe you have to put on. Stop sharing.
Sorry, I think I can just.
I'm just trying to see. Yeah.
Stop sharing will stop the presentation.
Stop recording.
Karthik, can you do it?
Yeah. Okay.
Okay, go ahead, sir.
Go ahead, sir.
I think I just no. Okay, I'm not able to find that button here right now.
Yeah.
Okay, no problem, sir. Okay, you are visible. We want you to be.
Yeah, thank you.
Close, sir. Sir need to close.
Yeah.
So that was the thing. And as we say even a corporate, in a board, you have different people. Okay, so insolvency professional is one of the persons who's trained to do that. But for a lot of specific inputs, he has to take the inputs of other people in going forward. And of course, he has to depend also on the existing management, because without the existing management, it's difficult.
Yeah. Sir, we have a question from our Ramchandra Garu. It's commonly heard that the benefits under the NCLT are being reaped through unreasonable haircuts. The second one, do you think that creditor files case under MSMED Act for the dues? Because mostly they depend on the company for future orders. Is it effective? The third one will be, is value of an asset not unique? Valuation of several today's startups are mind-boggling.
Okay, I see two hands raised, one from Sanjay Gadalia.
Sanjay Gadalia, yeah. Hello. And this is, these questions, you got it, sir? 3 questions from, hello?
Yeah, can you just repeat them? Sorry, first one is which one?
First, I think first one is it commonly heard that the benefits under NCLT are being reaped through the unreasonable haircuts. That's the first one.
No, this is a much debated issue. Okay, I may not be the right person to comment on it.
Fine. Okay.
But the banks, but the view of the ministry and is that it's okay, temporary blip in the due course of time. If the IBC framework works well, then these distressed assets should be picked up and dealt with quickly. And if they're done very early in the day, then the recoveries will be far higher. A lot of them actually were already cases which had been dead for a long time, almost the last 10-15 years, and there's nothing there to recover. So that's why the haircuts may have been higher. So this is at least the official position that I've been hearing.
The second one is value of an asset not unique. Valuation of several today's startups are mind-boggling.
Yeah,
valuation.
See, the startup valuation is a very, very different. It's not a very different thing. The methods are there, but the basis that they use has a lot of subjectivity, and they're all dependent on certain parameters. So, okay, but I think the valuers will obviously be in the best position to answer those. Because the person who's giving the value there is the right person to answer that question.
So can I ask the question? Come back at the side.
Yeah,
Sir,
please.
So one point, another question, sir, one more question unanswered is that under the MSME Act, creditor can file the case against the company for his dues. They're not paid within the 90 days or what is the stipulated time. But sir, the same supplier depends upon the vendor again. Do you think it is effective, sir? Do you think it happens? Really, is it happening in the real practical field? Because again, he depends on the same supplier for getting orders. He can't quarrel with him and then try to say, give me more orders.
Yeah, I have some sharing from a person who has actually effectively used the MSME Act. And he, and a lot of MSMEs face problems with government. With government usually. And he said that he has found it useful. And he said when you go back to them and you persist with it, see, don't get into a fight, but you certainly persist with the process and see if through conciliation you're able to get that solution. If it's not through arbitration, you get through. Because if you're coming to a stage where you're very desperate and you need the funds and it's a question of life and death for the company, then obviously that part of conflict you have to take. You cannot avoid it. But certainly you must manage the process well and see as far how far conciliation will help. If it does not, then you persist it and take it to the next stage. Is why people. Of course, he was saying that a lot of matters he could dissolve and resolve. Of course, he gave a side point. He said, if you are from Telangana, then you cannot get money back from Telangana government. But you can expect Telangana government to help you get money from other governments.
That's nice. Thank you, sir.
Sir, good evening. Kamlaka this side, sir.
Yeah, please.
Okay. We are a proprietor-run company since last 20 plus years. So is that any advantage is going into a limited liability or maybe a private limited for the sake of to get a more valuation, to get some funds in that aspect? And second thing is, once we convert our proprietary concern to a limited liability, maybe a partnership LLP or maybe a private limited, will that old experience and all old thing, will it be carried away to the new firm or not? How do we do that?
I just want to answer that. If you see that one slide I had presented to give you just an overview of the subject on conversion, because it's obviously a lot of factors involved there. It's not a simple. But what we said that, see, for a proprietary company, I was discussing this with some one person. I think he's also there in the audience today, and he was saying that see, the options are when you want to increase. Suppose you are growing very fast, like some of these startups today are doing. Okay, then you need huge amounts of funds. Okay, so when you want huge amount of funds, the choice of the entity that you're going to have will depend upon what the investors want and what the people are going to invest. So if you're a proprietorship company, then this is a problem, because then they don't have a site into your company. They cannot take a stake into your company. So willy-nilly, you have to look at either an LLP or a private limited company, thereafter going into a public limited company. But between an LLP and a public limited company, I was told that LLPs find it more difficult to raise funds because of the partnership structure and the decision-making structure within the entity. In fact, the best entity is to private limited company and then thereafter into a public limited company when you really grow big. Okay, now
how about the conversion, sir? Like,
now the conversion, what happens is, I think what I had read somewhere and what I've heard from some people, that normally when you have to incorporate a private limited company, and then you have to do a slump sale of whatever is there in the proprietorship company into the private limited company, and that's how you transfer.
Sir, Rajgaru, you can share your last side of your contact number. People are interested, they can touch with you in email. The time is running short now. Yeah,
thank you,
slide
sir.
you
Thank you. Thank you. Thank you.
Yeah.
I'd like to ask a question, Raju.
Yeah.
Am I audible?
Yeah. Sanjay ji, audible.
Yes.
How are you?
Yes. Thanks. I'm fine. Raju, wonderful
Sanjay.
presentation. You managed to make it quite exciting with all the colors and the presentation. As usual, the ITC way has always been the right way.
ITC.
I would say.
Okay.
So my question was a sort of a pulling out answer for you, because you have essentially been a creature of the corporate kind. After having worked with ITC for, I think, almost 30 to 40 years.
32 years, yeah.
32 years.
33 years. You essentially have actually seen the whole story from the other side, where the various vendors would have been running around you, trying to get your orders, and then negotiating the entire process, and ensuring that the relationships didn't sour, because they never wanted to lose such a golden goose also in the long term, in spite of maybe the peccadillos of the local individual managers who might come in for a short term and go away. Now, when you see it as a lawyer who's an arbiter, as compared to as a direct stakeholder, between the service provider or the product provider and the service receiver, that's a user, intermediate it might be as a B2B. What is the difference that you're seeing? I mean, how do you see it now as to be the right approach for all the stakeholders to operate, when we all know to a very large extent that the stakeholder with the least investment in the form of the government and the state is actually ripping both of us apart? How do you handle that?
Okay. Okay. First, I just wanted to explain, which I had also covered in the point. I don't know if you were there at that point in time. See, I was, without naming the company and all, I was in a division which was relatively a small component of the large company for quite some time. Okay, point number one. Point number two is that we were operating with a lot of MSME players in various ways. Okay, sometimes they were suppliers, sometimes they were partners together, and where we had to collectively deliver certain things. And sometimes we had customers also on the other side. Okay, so to that extent, and because of a long experience, I also have some friends who are also here who have actually run MSMEs, and we have had long chats on this subject. Okay, so that's there. I personally, if you ask me as an advocate, I think there are enough provisions available in the statutes and the regulatory framework. They need to be used appropriately, and they're used appropriately and persistently and with patience. I'm sure the results will come. And of course, I would also suggest that from an MSP perspective, they need to probably find some time in this thing to keep looking ahead, always a little ahead of their current situation, so they're able to better plan for themselves.
So the advisory is critical, having that overhead in your team, which actually allows you to have that head-up view of the policy and the government's understanding, is always critical. That is what is coming out very clearly,
So
which is unaffordable by an MSME again.
One of the deterrent factors for MSME, this again was shared by one of the participants with whom I was having a private chat. And his point was that, you see, a lot of MSME people also hesitate to go for legal things because of the costs involved. Okay.
Correct.
So actually, can there be a framework to help the MSME in terms of?
So that's why the partnership and the communication channel being open all the time, so that you don't allow the cat between the two the dogs who are apparently fighting to take away the bread, and the cat here being the government.
But okay, the current government's making a lot of good noises and taking a lot of new initiatives that are coming in, and I'm sure those things should help.
I think time will tell, but they should carry it through. That is the main story.
Yeah.
The main problem is carrying it through.
Sir, thank you. I think here also time is running short, sir. I think
Yeah,
I request Kochi Chandrasekhar Garu, please give closing remarks as well as vote of thanks to our guest speaker, sir. Please.
Yeah. Good evening, GMK Garu. Though they Murali Krishna Raju, we don't call him like that, it is GMK Garu.
GMK.
Transformation from manufacturing to a totally different level playing field. And I know what is ITC all about, what is manufacturing, what are the other functions are paid. And in fact, this calls for one full day session because otherwise it goes above our head. It got definitely, and as somebody mentioned, it is a highly insightful presentation. And in fact, when you talked about something on the ATR, accountability, transparency, and responsibility, ATR, you mentioned the corporate governance. See, like there is a SEBI rules, norms that every quarter company should announce the publish the results. And why there's not much mention about on the CG part and the corporate governance. See, SEBI clearly says about you have to publish the results once in a quarter. So where this CG, factored into corporate governance? Though
you want me to answer that? Yeah, actually, the transparency part is where all the disclosures come in, because as we know, in a corporate, there's a corporate veil. Okay, so by SEBI insisting on more and more disclosure, you are making sure that the far more transparency is being ensured. And that's there in the LODR requirements, which I had mentioned in the last page, in terms of requirements.
Okay.
I did not go point by point because, as we said, corporate governance itself can be a half a day session.
Annual report carries a separate report on this, sir.
True, sir, but despite all these regulatory, still, many companies really do not get in. Like as rightly said, Sachem is one example of not complying with the corporate governance and got into various problems. That's a part. It's already taken more than 30 minutes of our time. And thanks once again, GMK Garu, for taking your time and giving us the insights from the complete legal aspects of MSME and even private, and what is the difference between private limited and public limited company. We always look forward for your support and guidance to HMA, not only on this MSME alone, we look forward for another ASA as well. And I thank our President Ramchandra Garu and mainly Rajendra Prasad Garu, who has organized this lecture, and other members, and Sanjay was also visible today throughout, and other members who have participated and really got benefit out of that. I thank once again all the members. Our presidents, our past president, another past presidents are present today. And we will look forward for many more sessions from you, GMK Garu.
Good.
Transfer, where were you in ITC manufacturing 36 years?
Yeah.
Suddenly got into totally advocacy now.
Thank you.
Great.
So let's just make sure that our innings are extended. Because as you know, you can carry on.
Mechanical engineer, sir. More so you're a mechanical engineer again.
Yeah.
Oh, and
Yeah, nice.
GMK has got such a beautiful command over the language. I think we should think about having a legal desk at HMA, especially
Right.
from the managerial perspective.
We'll do that.
GMK should
We'll do that.
the team on.
In fact, I was mentioning that he crammed up so many things, the entire law related to the industries, he has crammed up in this. Saying the laws made over a period of years over with the huge amendments and the corrections and the latest position also. I think, sir, every slide is important. I think probably the presentation will be a very useful document. Thank you very much once again.
Thank you.
And you have HMA and
With this, we come to the conclusion of this session, sir. Thank you very much.
Thank you.
Thank you, Raju.
Thank you.
Thank you, Raju.
close.
Thank you, and GMK Garu.